All rise. Good morning. 13th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or arms resting on benches. If you have a cell phone, put it on silent. Thank you.
This is case number 24-173157. This is Capital One versus Alicio Renuso. Now, the matter is before the court. This is the first hearing regarding this matter. The claim in this matter alleges damages in the amount of $1,699.45. So your appearance for the plaintiff, please.
Good morning, Your Honor. Andrew Cates, P78292 for the plaintiff, Capital One, in this matter.
Thank you, Mr. Cates. Good morning to you. I'm looking now for last name Renuso. If you're on the Zoom, please say something at this time. Looking for Alicio Renuso. Right, Counselor, you had any occasion to have contact with the defendant regarding today's date?
I have not had any personal contact with this defendant. I am in receipt of his answer, but his answer generally seems to agree with all of the allegations in the complaint.
Yeah, I do see that. Just wondering about that the defendant's whereabouts. The record should reflect that the court did cause a notice to be sent on the 6th of March of 2025, indicating today's hearing regarding this matter. That notice was sent to the address that was provided by the defendant in the defendant's answer. It appears that the defendant has not appeared. Counsel, your pleasure at this time, sir.
Your Honor, I would request the entry of a default judgment just based on the defendant's failure to appear.
All right, based on the defendant's failure to appear and the general nature of the answer as well in this matter, it does not seem to be a matter that's truly contested. But moreover, of course, the defendant has not appeared. Accordingly, the court will find that the defendant is in default, and on that default, the court will allow for the entry of judgment upon presentment. The default is entered at this time based on failure to appear so ordered. Thank you, counsel. May submit your order.
Thank you. Have a good day, Your Honor.
Thank you. Likewise. Court now calls 25-144497. This is NB Funding LLC versus Vera Reynolds. The matter is before the court, set on for status conference. The record should reflect that the claim in this matter is $2,358.69. This is the first hearing regarding this matter. Your appearance for LB Funding, please.
Good morning, Your Honor. Michael Bankstein, P69778 on behalf of LVNB Funding.
All right, thank you, Mr. Bankstein, and good morning to you. I'm looking now for Vera Reynolds. All right. Thank you, Ms. Reynolds, and good morning to you as well, ma'am. I do know that you submitted an answer regarding this matter, and just looking at a couple of things here. All right, so what happens at this point typically is the parties try and see if they have any basis for reaching some type of agreement to try and resolve the case. Short of that, what the court does is sets up the next set of hearings, the next stage of the case, issuing a scheduling order and allowing for discovery. I've looked at the nature of the answer, of course, of the complaint, and it seems like there is of course a dispute. But I guess my question here is: are you looking to find some way to reach a consent in this matter, or?
Yes, I am with GFT, and they're taking money out of my account to cover these things. And right now they say they have been trying to reach out, but they haven't been answered. So this is why we're in the situation.
All right. All right. So, counsel, Miss Reynolds is in the courtroom, and she's indicated that that some money has been taken from her, that she's been reaching out, trying to get this resolved, and nobody's been returning her calls or something along those lines.
I can answer those questions, Your Honor. First of all, we haven't taken any money. I believe she's referring to her debt consolidation company has taken money out of her account. We have not received any money from her. I want to let you know that. And we wouldn't be able to do that until we got a judgment. So I believe she's referring to the debt consolidation company. Typically, the debt consolidation company approaches us and starts some kind of negotiation. I'm not seeing any indication that they've called us. I'm looking through the call notes. People frequently say that, but many times, and that may be what she's been told. I see that we made an outbound call to her debt consolidation company October 15th, received no answer. Still scrolling through the notes. I don't see any incoming calls from them. So I mean, I believe that Ms. Reynolds believes that to be the case, but I'm not seeing any incoming calls from her debt consolidation company. In fact, I see where we've called them and not gotten a response. What I can do is I can give her my phone number and email address. I'm not going to contact her because she has a debt consolidation company. But if for whatever reason she was to make me an offer in terms of a settlement or a payment arrangement, I would entertain the offer.
All right, so we'll set it up in that way so that that any exchanges can be made that are appropriate. When Ms. Reynolds raised the issue of money being collected or taken from her, of course, I raised that issue because sometimes the parties are in the process and they reach some agreement that has not made it to the court yet, and that payment should be taken. Now I understand better that this has to do with a situation involving debt collection or debt consolidation company. Is that correct, ma'am?
Yes.
All right, so
And I want to correct the record, Your Honor. I do see where they did finally call us back on February 19th and said they'd be contacting us in 3 to 5 days. Again, that was back in February. So it looks like they did several months later return our phone call.
all right, got it. Well, that's very interesting how all that plays out. Well, counsel, what I want you to do is chat the information that I can convert, that I can give to Ms. Reynolds for purposes of trying to reach out to you. Now, I have the information, the phone number as indicated on the pleadings. If you're offering something different than that, and you want to chat it to me, and I'll get that information to you. I do not have an email address, so you want to certainly chat that to me. I'll make sure that Ms. Reynolds gets that information. What I'm going to do in the interim is I am going to set this up on a pretrial schedule. The parties can continue to negotiate and try to get it resolved. The pretrial schedule sets the matter up for a 60-day review or 60-day pretrial. That pretrial is going to take place July the 16th. Sorry.
All right.
July the 16th at 9:30. You're going to get some paperwork from me in the mail with that date on. During that 60-day period, we'll be open for discovery. Parties can put in writing any requests that they may have on the other side, and the other side is required to answer those requested items. So that will be a part of this next 60-day period. Again, the new date will be July the 16th at 9:30 a.m. And again, you'll get that from me in writing in the next couple of days. And Ms. Reynolds, I will make sure that contained within that document will be the information you reach out and contact Mr. Bankstein in this matter. All right, I do wish the parties well, counsel.
I just want to make sure we got July 16th at 9:30 a.m. for the next pretrial, 60 days of discovery. What's the cutoff for filing a motion for summary disposition, Your Honor?
I have not addressed that as of yet. I will address that on the 7th. Strike that on the 16th. You will notice.
Okay, thank you, Your Honor.
You'll notice under provision number 6 in the scheduling order that you can file motions under an abbreviated schedule based on the court's order. So you'll see it under paragraph number 6 of my schedule.
Thank you, Your Honor.
All right, thank you. Good day to both sides.
Have a great day.
All right, thank you. court now calls case number 24153426. This is Citibank versus Rashida Taylor, also known as Rashida Miles. The matter is before the court, set on for a pretrial conference, as well as the court is in receipt of a motion for summary disposition in this matter. That motion was filed with this court February the 25th, 2025. Your appearance for the record for Citibank, please. For Citibank. Counsel for Citibank on this matter. Let me do one thing that means the counsel will be voted on this matter. I'm looking for counsel for Citibank. Looking for counsel for Citibank. Who is that on the Motorola phone? On the Motorola phone, please say something. Please identify yourself. The person that just came in on the Motorola phone must identify yourself.
Hello?
Yes, who are you?
Could you hear me?
Who are you?
Sammy Fullerton.
What case are you on?
On the case with for Gardner White.
Trial Judge 783.
Okay, all right. All right, go ahead and mute yourself. I'll come back to you in just a moment, sir. Thank you.
Okay.
All right, do I have Rashida Taylor on this Zoom? Rashida Taylor? All right, the matter is set on for a settlement conference on today's date. The parties indicated at the last hearing that they were close to a resolution. Neither side have appeared at this time. That may mean that they've reached a resolution in this matter. I will revisit this matter at the end. The court now calls case number 18-175831. This is Comerica Bank versus Tiffany Young. The matter is before the court on the issuance of a subpoena. Your appearance for Comerica Bank, please.
Kenneth Tardy here on behalf of Comerica Bank, P25044.
All right, thank you, Mr. Tardy. Good morning to you.
Good morning.
I'm looking now for Tiffany Young. If you're on the Zoom, please say something at this time.
Yes, this is Tiffany Young.
Ms. Young, and good morning to you. This matter relates to a judgment that was entered on the 18th, strike the 8th of January 2019 for $5,205. This is an effort by the plaintiff to collect the balance on that particular judgment, and that therefore they've issued a subpoena. Counsel, have the parties spoken, going into a breakout room or anything regarding this matter, sir?
Not as of yet, Judge, but I would request that we be assigned a breakout room.
All right, I'll do that so the parties can address the issues raised by the subpoena. So I'm going to send you a notification, Ms. Young. You'll be able to come back in the courtroom afterward, and counsel is going to be there addressing issues related to the subpoena. So you're going to receive that notification in just a moment.
Could we have a clerk or have someone swear her in? the creditor's exam.
Thank you, Council. Let's do that at this time. Raise your right hand and be sworn at this time. You do solemnly swear or affirm that the information that you'll provide pursuant to the subpoena that has been issued in this matter will be the truth, nothing but the truth, so help you God. Is that correct,
Yes.
ma'am?
Yes.
Now, Council, have you discussed at all any agreement for payment or anything along those lines? Have there been any discussions?
We have not, Judge. I hope to do that in the breakout room. The balance is less than $1,000 right now. So, I would hope a couple of payments could pay it off. So,
Yeah, that makes sense. All right, so let's see if we can get to that. So there's the notification, and Council, there is the notification. All right, I'll see both of you on the other side. All right, this is case number 24160783. This is Synchrony Bank versus Sammy Fulton. The matter is before the court set on for a trial on today's date. The claim in this matter alleges damages. Just one moment. In the amount of $6,970.01. Or your appearance for the plaintiff, please.
Good morning, Your Honor. David Monroe, P18081, Appearance Counsel for Mr. Wake and Synchrony Bank.
All right, thank you, Counsel, and good morning to you, sir. All right, I'm looking now for Mr. Fulton. I know that you are there. Good morning to you, Mr. Fulton.
Good morning, sir.
All right, this matter is set for a trial hearing today for the court to reach a determination as to the outcome of this matter that has been pending before the court since last year. It looks like to me, from what I've been able to see, that the dispute here does not relate to whether or not something is owed, but the dispute here is regarding how much is owed. Is that correct?
That's correct, Your Honor.
Is that correct for you, Mr. Fulton?
Yes, sir.
So you agree that you owe something, you're disputing what the amount is, correct?
Yes, I'm disputing them out.
Okay, all right, so the court will make the finding on the undisputed facts that there is a balance that is owed regarding the complaint between parties, and that the issue that is before the court is the issue that relates to the amount that is owed. The court will hear issues related to the claim of damages in that regard. Right, it is so ordered that the parties, by virtue of their stipulations and by virtue of the nature of the pleadings, there is no genuine material dispute as to whether or not there is a claim for damages. The only dispute is as to the amount of damages. We will proceed in that manner. Counsel?
If I might, Your Honor, if the court could assign Mr. Fulton and me to a hearing room where we can discuss possible settlement of that amount due, I would appreciate it.
That does make sense, and I appreciate that, Counsel. Mr. Fulton, it really makes sense to talk about it now, given the posture of things. So I'm going to send you a notification to go to the breakout room with Counsel, Mr. Monroe, and see if you guys can talk about it, and maybe come together on what the numbers might be. So there is your notification for you, Mr. Monroe, and excuse me, for you, Mr. Fulton, Mr. Monroe, yours is coming. Right. Now, there you go. So go ahead and click in, and I'll be waiting on the other side.
Well, thank you.
good this morning. They get you some assistance around it.
Not really, not yet. I mean, she helped a little bit yesterday, but it wasn't nothing, so they said they ain't had nobody so far, so. I'm just working on day by day, getting it down though.
Yeah, I know. There's a lot. I was shocked.
Yeah.
But I've never seen it. I went over there. This Thursday evening. I was like, what is this?
Yeah, they just said people just keep on, it's filing a bunch of bulk stuff. Yeah. So I gotta get out of here at 2:00 today. It was your birthday.
Was that
It's my grandbaby's birthday, so I gotta
Wow.
get out of
a year already? Huh?
here. Yeah, just.
Gee, I can't believe it. That was July the 16th, I gave, right?
Mm-hmm.
You remember the attorney's first name, Big Steen's first name. You remember his first name, Big Steen.
The guy who just on the screen,
Yeah, the one that,
you gonna get a phone number?
yeah. I'll All right, we're back on the record regarding the suffix 581, that's American Bank versus Tiffany Young. Right, then welcome back Mr. Tardy, and welcome back, Ms. Young. Mr. Tardy, you may update the court at this time, sir.
Yes, Your Honor. Ms. Young was cooperative, and we've come to a payment agreement of $100 per month beginning May 20th, 2025. I'm going to be sending an email over to Ms. Young with my address and phone number and so forth. And hopefully that's the last you'll hear from us, except for filing a satisfaction of judgment in about 9 months or so.
Great, Ms. Young, that makes sense to you, and this is your agreement as well?
Yes, it is.
All right, so I've noted the file that the parties have reached an agreement that going forward, $100,000 paid monthly until the judgment is satisfied. That first payment will be due on May 20th, 2025. And moreover, that the parties have agreed on what the balance is and anticipate a satisfaction on the balance being paid. That a correct statement of the resolution, counsel?
It is, Judge.
Ms. Young?
Yes.
All right, good day to the two of you. I will, the file will note that it's already, there's already been a judgment, whatever, on this. So as soon as the satisfaction is due, then the next action.
Okay. Thank you very much, Judge, for your time. Ms. Young, nice meeting you. All right.
You too. Thank you.
Bye-bye.
Your Honor, David Monroe, I'm back with you. I don't know whether Mr. Fulton is back or not yet.
Yeah, I'm here.
All right, welcome back to the parties on the suffix 0783. And I know the parties went to the breakout room to discuss the matter. It is set for trial. Counsel will update the court on where things are at this time.
Unfortunately, Your Honor, Mr. Fulton and I are in somewhat substantial disagreement about the balance of funds that is owing. We're not in a position, well, let's put it this way. We filed, it's an account stated claim. There's an affidavit of the amount due in the file. The plaintiff did not file a motion for summary disposition as they thought that they were going to be able to reach a settlement with Mr. Fulton. Apparently that's not happening. I would request the court adjourn the matter so that we can file a motion for summary disposition, bring it that way.
All right, so the challenge here is this was something that I noted in the file that I knew that this would come up if the parties have now reached a settlement. And that is that an affidavit relative to an account stated was filed in this matter. And no contesting affidavit was filed in response to that at the time of permitted by law.
That's correct, Your Honor. And on top of that, he didn't file any answers to interrogatories or requests to admit as well.
All right, counsel. I'll let you get away with interrupting me that one time, but not again. All right, the main point here is that Mr. Fulton, that creates a problem with you at law. That you would have had to file an affidavit in the time permitted by law to contest the account stated. And so the account has become stated, and you did not file an affidavit in response to that. So my thought in regard to this is that if you are in a position, or if you are being offered something that's less than the full balance in this, you want to look long and hard at that in terms of considering what you're going to take, because if a motion is filed, even orally, that motion could likely result in it being found that you owe the full amount just based upon the fact that you didn't respond to that part of the complaint. That is the account stated part. Account stated is a way of saying that the account has been created, that notices were sent out and that the defendant did not dispute the amount at all. And then what happens is that if that account is submitted, the defendant has to write by law to file an affidavit contesting that. They has to do it within the first available time to do it, typically within 28 days of the filing of the complaint. No responsive affidavit was filed in that regard. That's the issue that is raised in this case. So my challenge is I would likely adjourn it, but the big challenge here is that without there being a response to the affidavit file, then it puts you in a position where, Mr. Reynolds, you want to look at this. Mr. Sure, not Mr. Reynolds, Mr. Fulton. You want to make sure that if you're offered something less than the full balance, that you probably want to find a way to take that. All right, so that's what I wanted to say. I don't want you to, if you can get something less than what is the full amount, you definitely want to try and take that rather than get a motion or go to trial, and because of that non-affidavit, you end up having to pay the full amount. You understand what I'm saying to you, Mr. Fulton?
Yeah, I understand what you said, but we had an agreement and they trying to go against the agreement. And when they accept all the money except for the last payment. So I only owe them $1,100 according to the agreement.
All right, well, why didn't you file an affidavit contesting the account stated when the complaint was filed against you?
I don't know nothing about no affidavits. I went down there and I did what I thought was right. So I don't know them. Then I can't file a lawyer that take the case because they said there ain't enough money.
Yeah, I understand that.
Yeah, but see
All
what they doing, they breaking their own agreement. They trying to go against their own word.
Right. All right, so I will definitely take a look at the agreement. I think council is going to file a motion in this matter. And I suppose that when they file that motion, you want to attach the agreement to the motion so the court can take a look at what the agreement was. All right, so here's what I'm going to do. I'm going to set the date for hearing on the motion for summary disposition. I'm going to set that for the 30th of June. That gives the plaintiff the opportunity to file at the time, and it gives you, sir, Mr. Fulton, the opportunity to put something in writing in response to that, and perhaps a copy of the contract that you indicate it should resolve this matter. So I will set the hearing date on the 30th at 10 o'clock a.m., June 30th, 10 o'clock a.m.
Hey, how you doing, sir? The lady across the street, you know her?
Hello.
Talking about you.
I'm on a Zoom call.
Oh, okay, all right. She said something about once.
So something wrong with her?
Yeah.
All right, Mr. Fulton, you'll get the notice in the mail from me as well as council setting this for the 30th of June at 10 o'clock a.m. For the hearing on the motion. All right, good day to both sides.
Thank you, Your Honor. I have it. Motion for summary, June 30, 10 o'clock. Appreciate it.
Thank you. Good day.
Good day to you, sir.
On the Citibank versus Rashida Taylor matter, the suffix is 3426. That matter is going to be dismissed at this time where neither party appears. Mr. Fulton, you'll get your notice in the mail, sir. I wish you well. I'll see you on the 30th of June.
So that's good.